Roger B Taney was born on March 17, 1777. No, not 666, but close to it. In Calvert County, Maryland. No, not the land of Marys, I mean Maryland, where everyone says the letter O louder than any other letter. He is one of 6 children, and the second son to a successful farmer. Not a normal farmer, a tobacco farmer. He had been educated in France, but later attended college in Pennsylvania instead of taking on the family business of farming tobacco. Roger was married to Anne Key, whose brother was Francis Scott Key, who, as you may all know, wrote the Star-Spangled Banner. Well, I didn't know, but that's enough about his family and friends. Now on to the important stuff. Not that his wife was not important, I'm saying his important role as a Chief Justice and his benefits towards our nation. Oh, and yeah, Taney was a member of the conservative property-conscious Federalist Party until 1812, until the party opposed the war against England. He returned to Maryland House of Delegates in 1816, and even before becoming the Supreme Court's 5th Chief Justice in 1836, he served as an Attorney General and Secretary of the Treasury in 1821. That's when he went to study with Judge Jeremiah Chase, who was also a very successful Chief Justice, but that's for another day. He was also recognized as an excellent lawyer. Juries were impressed with his sense of fair play and his courtesy towards opposing attorneys. In 1827, he was appointed Attorney General of Maryland. By this time, he had aligned himself with Andrew Jackson, a leader of the Democratic Party. Taney especially made history in 1857 with the Dred Scott case by ruling that black slaves were not citizens of the United States. This controversial historic figure died on October 12, 1864, in Washington, D.C. Hustler Magazine versus Falwell. The question that was argued was, does the First Amendment freedom of speech protection extend to making of patently offensive statements about public figures, resulting perhaps in their suffering emotional distress? The question was argued November 1983. They issued a parody of a advertisement that included the name and picture of the respondent. The ad was supposed to mimic Campari liqueur ads, the focus on someone's first time trying the product. The parody was titled, Jerry Falwell Talks About His First Time, the Respondent. The parody advertisement showed the respondent's first time as a drunken, incestuous encounter with his mother in an outhouse. The respondent brought the suit on the grounds of invasion of privacy, libel, and intentional infliction of emotional distress. Falwell won a jury verdict on the emotional distress claim and was awarded a total of $150,000 in damages. Hustler Magazine appealed. The District Court and the United States Court of Appeals for the Fourth Circuit found for petitioner on the defamation and invasion of the privacy claims on the grounds that no reasonable person would consider the parody as true. They held for a respondent on intentional infliction of emotional distress. Public officials were held unable to recover an emotional distress. They could not prove that the publication was made knowingly with actual motive. Because the respondent was a public figure, he could not claim emotional distress. The court added, under the First Amendment, surpassed the state's interest in protecting public figures from patently offensive speech, so long as such speech could not reasonably be construed to state actual facts about its subject.